From regulation to crime control, preventive justice in the governance of global markets. Dennis J. Baker, Chinese Journal of International Law, Volume 25, Issue 1, March 2026. Abstract: this essay analyzes the criminal turn in economic governance, where national security priorities embed preventive justice rationales into global market, trade, investment, and technology regulation. Drawing on the frameworks of preventive justice and securitization theory, it illustrates how systems in China, the United States, and the United Kingdom employ anticipatory coercion, strict liability sanctions, definitional vagueness, and procedural opacity, discarding traditional criminal safeguards such as mens rea and proportionality. Comparative evaluation exposes converging preventive architectures across divergent constitutional models, producing chilling effects, delegated enforcement, multilateral fragmentation, and threats to economic openness. It advocates limited consequentialist reforms to reconcile security imperatives with rule of law integrity. This is an open access article distributed under the terms of the Creative Commons Attribution License, which permits unrestricted reuse, distribution, and reproduction in any medium, provided the original work is properly cited. Introduction: The criminal turn in economic governance. Introduction: The criminal turn in economic governance. 1. As great power rivalries intensify and digitalization reshapes every domain, national security is undergoing a profound transformation. No longer limited to territorial defense or conventional military threats, national security now penetrates the key arenas of economic liberalism, encompassing foreign direct investment, international trade, financial transactions, data circulation, and technological advancement. This widening scope reflects structural transformations in the global political economy and the resurgence of strategic rivalry among major powers, propelled by vulnerabilities revealed through pandemics and armed conflicts, and by the dual-use character of emerging technologies that obscure civilian-military distinctions. Central to contemporary global frictions is the dynamic termed the Thucydides trap, denoting the structural apprehension that emerges when an ascending power, China, contests the hegemonic dominance of the United States. Though accounting for barely 4% of the world's population, the United States strives to uphold a system of unipolar dominance that has long ensured its strategic, economic, and ideological supremacy. But as demographic and economic momentum steadily shifts toward larger and faster-growing states, the US increasingly resists the natural reconfiguration of global power. Instead of adjusting to the logic of a multipolar order and redefining its approach to integrate rising powers, it clings to the hierarchies of a waning era. This reluctance to distribute influence more equitably not only erodes the legitimacy of the prevailing international framework, but also converts strategic rivalry into confrontation, amplifying the dangers of misjudgment, conflict, and systemic disruption. 2. Contemporary great power rivalry is increasingly defined by competition for technological preeminence. Artificial intelligence, quantum computing, advanced semiconductors, biotechnology, and telecommunication systems are now widely identified as dual-use technologies, serving both civilian economies and military strategic objectives. Mastery of these domains, including intellectual property, technical standards, supply chains, and specialized human capital, has become integral to assessments of relative capability and geopolitical leverage. This technological frontier of strategic rivalry creates novel problems for legal and regulatory governance. Technologies today defy conventional territorial constraints. Software traverses borders instantaneously. Data circulates ceaselessly through transnational networks, and intellectual property shifts via mergers, talent mobility, or cyber intrusion. The intangible, interconnected, and rapidly mutating character of digital technologies erodes traditional governance models grounded in territorial jurisdiction, physical oversight, and static definitional boundaries. 3. What is obvious to the United States is that should Beijing secure indigenous 3nm fabrication capabilities, circumventing the ASML choker point through advanced lithography alternatives such as nanoimprint or directed self-assembly, and simultaneously liberalize renminbi convertibility, thereby transforming Shanghai and Shenzhen into credible alternatives to New York and London as global capital destinations, the foundations of the Magnificent Seven's platform hegemony will face existential dismantlement over the next 2 decades. Unconstrained by export controls and equipped with unlimited state capital, Chinese laboratories will orchestrate a wave of civilizational cost innovation, quantum AI hybrid architectures, biological edge computing substrates, and zero trust distributed networks that render the current cloud leasing model is obsolete as the mainframe. Operating at manufacturing scale efficiency, the China price applied to cognitive infrastructure, these emergent technologies will not merely undercut Oz or Azure on marginal cost, they will enable ecosystem inversion. Wherein Beijing's technological complex offers the foundational protocols, industrial standards, and developer environments for the Global South and eventually segments of the OECD, abruptly converting Apple's hardware margins. Nvidia's CUDA lock-in and Meta's data moats into stranded assets. This is a simple economic war. 4. The economic carnage will mirror the earlier collapse of American textile and steel dominance, but compressed into a decade rather than half a century. As Chinese platforms capture the 70% of operating profits currently monopolized by American hyperscalers, the US economy will suffer a revenue hypercost that severs the 92% GDP growth contribution currently generated by tech investment, triggering a secular stagnation from which the dilapidated industrial base cannot recover. In this scenario, the criminal turn in economic governance, America's earlier attempt to weaponize regulatory opacity and preventive sanctions, will be remembered not as a safeguarding of strategic advantage, but as the desperate final barricade thrown up by a technological aristocracy already marked for obsolescence. 5. The technology of the future will not be dominated by crypto technology or cloud computing, both of which remain profoundly inefficient in energy consumption and physical space requirements. Instead, the true horizon lies far beyond what even the most visionary scientists can currently imagine, as the next breakthroughs will emerge not from incremental improvements but from truly evolutionary leaps, paradigms that rewrite the fundamental rules of computation itself. Quantum computing will be the first seismic shift, unlocking AI capabilities that are not merely faster or more powerful, but qualitatively different and entirely unforeseen today. Nonetheless, even quantum will likely prove only a stepping stone. The real future will unfold through discoveries so radical that they remain outside the field of view of today's leading minds, evolving in ways that defy prediction and reshape civilization in manners we cannot yet comprehend. It is highly likely many of these leaps will come from the East, and this is central to the current securitization and criminalization of technology transfers. 6. As Professor Needham documented in his monumental Science and Civilization in China, the Middle Kingdom was the preeminent technological superpower for millennia, inventing gunpowder, the compass, printing, and advanced hydraulics, while Europe languished in feudal darkness, only to experience a Needham paradox of temporary stagnation during the Mercantile Age. History reveals, however, that technological civilizations rarely stay suppressed. Rather, they enter agonistic overdrive when confronted with existential rivalry and containment. Washington's strategic sanctions, constricting access to lithography, AI processors, and quantum hardware, have unintentionally recreated the dynamics of the Cold War space race, propelling Beijing's domestic innovation well beyond what market incentives by themselves might deliver. Barred from the easy road of technological reliance, China has revived the inventive energy that defined the Tang and Song eras, blending state capitalist scale with a civilizational memory of scientific primacy. Within this dialectic of containment, the effort to defend American technological dominance becomes the mechanism of its erosion, because societies that once ruled the summits of human creativity need no permission to regain them, only external pressure to reawaken them. 7. The United Kingdom has likewise adopted securitization and criminalization through flagship legislation, including the National Security and Investment Act 2021, together with expanded sanctions, export controls, and tightly scoped economic offences. These initiatives mark a clear turn toward embedding criminalized reasoning within economic governance. Preventive enforcement, risk-based intervention, procedural opacity, sweeping executive discretion, and strict liability sanctions, staples of modern criminal justice, now govern transactions labelled security-sensitive. A transaction need not entail demonstrated misconduct. The simple projection of possible harm, frequently grounded in classified intelligence or conjectural evaluations, is enough to justify state coercion. Non-notification can nullify transactions ab initio and invite imprisonment of up to 5 years, erasing boundaries between procedural missteps and substantive dangers. 8. This essay offers 3 original contributions. First, It constructs a systematic theoretical framework integrating preventive justice theory with securitization analysis to explain how economic regulation appropriates criminal law's coercive mechanisms, while discarding its normative protections. Second, it delivers the first sustained comparative examination of China, the United States, and the United Kingdom, demonstrating convergent preventive logics across divergent constitutional structures and revealing how all three jurisdictions employ expansive national security concepts to justify anticipatory intervention and criminal penalties for non-compliance. Third, it advances a constrained consequentialist normative framework proposing concrete institutional reforms, including evidentiary scaling, special advocate procedures, sunset provisions, and specialized tribunals that reconcile legitimate security imperatives with rule of law commitments. By characterizing these developments as a criminal turn in economic governance, this analysis reveals how preventive rationales, once exceptional, now normalize suspicion-driven authority, prompting critical reflection on safeguarding legality, fairness, and open economic ordering within a digitized, contested global landscape. 9. This essay advances the argument that modern national security law, as applied to investment screening, trade regulation, and global economic governance, is most productively understood through the lens of criminal law theory, particularly theories of preventive justice, conceptions of harm, and processes of securitization. National security has become a juridical technology of preemption, fundamentally reconfiguring the relationship between state authority, market ordering, and individual responsibility. This transformation prompts deep normative inquiries into legality, proportionality, procedural justice, and the substantive understanding of the rule of law within an age shaped simultaneously by strategic rivalry and digital fragility. 2. Preventive justice and the security turn in economic governance. Traditional criminal justice operates retrospectively in that it punishes completed wrongdoing, where culpable individuals have caused or risked identifiable harms. Central to this model are foundational principles: mens rea guilty mind, actus reus wrongful act, proportionality between sanction and culpability, and fair labeling that distinguishes grades of wrongdoing. This backward-looking framework reflects liberal commitments to personal autonomy and governmental restraint. Coercive authority is warranted solely once misconduct is demonstrated, and only toward actors who elected to breach established legal norms. The National Security and Investment Act 2021, hereinafter NSIA, constitutes the United Kingdom's most consequential restructuring of investment governance in recent decades. Moving away from prior dependence on competition law regimes that emphasized market efficiency and consumer welfare, the NSIA elevates national security to an autonomous regulatory aim. The Act grants broad authority to the Secretary of State to examine, condition, or block transactions within 17 specified sensitive sectors encompassing artificial intelligence, defense, critical infrastructure, data systems, quantum computing, and synthetic biology. 11. The NSIA's preventive rationale is overt and unequivocal. Its statutory threshold for intervention rests on the mere possibility that a transaction may give rise to a risk to national security empowering coercive action without proof of actual threat, malign intention, or unlawful conduct. Transactions within specified sectors demand compulsory notification and ministerial authorization. Executing a transaction without such approval renders it void ab initio and exposes parties to civil fines up to £10 million or 5% of global turnover, alongside criminal penalties including imprisonment for a maximum of 5 years. 12. Crucially, these sanctions operate irrespective of subjective intent or even knowledge of the legal requirement. The offence structure embodies strict liability for procedural non-compliance. This marks a significant break from orthodox criminal law principles mandating mens rea for serious offences. Although strict liability is tolerated for minor regulatory breaches, the Supreme Court has consistently affirmed that faultless criminal liability must remain exceptional and narrowly confined. Nevertheless, the NSIA imposes potentially grave consequences, heavy financial sanctions, and extended imprisonment for conduct involving neither subjective culpability nor any demonstrable risk to national security. 13. From a criminal law theory perspective, this strict liability structure collapses the normative distinction between mere procedural noncompliance and substantive security threats. Well-intentioned investors who inadvertently fail to notify transactions, or who reasonably but incorrectly assess their transactions as falling outside notification requirements, face penalties identical to those faced by hostile actors deliberately seeking to evade scrutiny. This undermines fair labeling, the principle that criminal law's expressive function depends upon maintaining meaningful distinctions between different grades of wrongdoing. It also generates disproportionate outcomes where technical violations attract severe punishment despite absence of any culpability or harm. 14. Preventive justice entirely changes this rationale. Instead of penalizing previous crimes, it aims to block future ones via early action, proactive detention, and risk-centered control. Ashworth and Zedner define preventive justice as state authority, restricting or guiding people, regardless of former behavior, solely to prevent possible upcoming injury. This shift manifests in anti-terrorism legislation, indefinite detention schemes, and control orders that restrict liberty based on predicted dangerousness rather than proven guilt. Fundamentally, preventive measures typically eschew conventional protections whereby absolute liability supersedes criminal intent. Conjectural threat evaluation displaces tangible proof, and administrative obscurity is rationalized through security considerations. 15. When applied to economic governance, this analysis shows how national security processes increasingly function as preventive regimes. Investment screening under the UK's NSIA exemplifies this, since transactions trigger state intervention, not because they involve wrongdoing, but because they might create future risks. The statutory trigger that a transaction may give rise to national security concerns authorizes coercion based on possibility rather than probability, let alone proof. Failure to notify becomes a strict liability offence carrying 5 years imprisonment, collapsing the distinction between procedural non-compliance and substantive threat. Well-intentioned investors face sanctions identical to those faced by hostile actors, violating the fair labeling principle that criminal law's expressive function depends on meaningful moral distinctions between different wrongs. 16. Securitization theory, developed by the Copenhagen School, explains how issues are discursively constructed as existential threats requiring exceptional measures beyond normal politics. An issue becomes securitized when successfully presented as posing such grave dangers that extraordinary actions, emergency powers, suspension of rights, departure from legal norms are legitimated. Securitization operates as an Austinian performative speech act rather than a diagnostic assessment. An issue becomes a security threat not through the verification of objective danger, but through the successful articulation of existential risk by authoritative voices, typically state officials, military leaders, or institutional experts, to audiences primed to accept such framings. In this rendering, security is constituted by the utterance itself. When a recognized securitizing actor persuades a relevant audience that a referent object faces imminent peril warranting extraordinary measures, the threat is thereby instantiated, regardless of empirical severity. The efficacy of the move hinges on the speaker's social capital and the audience's willingness to receive the security logic, making securitization fundamentally a matter of political persuasion and discursive authority, rather than objective risk analysis. 17. Economic regulation experiences securitization when ordinary commercial transactions are transformed into prospective existential dangers, thus producing a fundamental epistemological fracture in regulatory logic. Within this paradigmatic transformation, the specialized vocabularies of market optimization, consumer protection, and antitrust doctrine are comprehensively displaced by the interpretive frameworks of intelligence evaluation, confidential evidentiary systems, and hypothetical risk projections that function outside traditional standards of demonstrability. Concomitantly, the administrative procedures of notice and comment, proportionality review, and transparent adjudication yield to exceptional enforcement processes, criminal liability without mens rea requirements, asset freezes predicated on secret evidence, and procedural injustice justified by national security prerogatives that function as sovereign suspensions of the normal juridical order. Ultimately, this transformation establishes a hierarchical axiology wherein security imperatives assume an absolute precedence, enabling the temporary bracketing of economic openness, due process guarantees, and international legal obligations in favor of a decisionism logic that privileges the preservation of the economic order over the procedural norms that ostensibly constitute it. 18. Whereas conventional administrative taxonomy misleadingly assimilates national security investment screening to the routine architecture of regulatory oversight, equating it with competition review, environmental assessment, or consumer protection as if it merely constituted an additional technocratic layer, preventive justice theory exposes the juridical rupture at its core. This reveals that such regimes instantiate a pro-crime logic that fundamentally inverts the temporality and moral process of legal intervention, rather than responding to completed wrongs or demonstrable harms. They operate through anticipatory coercion that treats future risk as present danger, substituting categorical suspicion, guilt by association with designated risk classes, national origin, sectoral affiliation, technological capability. For individualized culpability and imposing punitive disabilities, prohibited transactions, mandatory divestitures, ownership restrictions, absent any finding of legal wrongdoing. 19. This preventive turn is neither accidental nor self-legitimating. Securitization theory illuminates how these aberrant rationalities are rendered authoritative through performative speech utterances that transmute ordinary commercial investments into existential threats to the state, thereby suspending the normative constraints of law and permitting the deployment of emergency powers within ostensibly peacetime economic governance. This reveals the emergence of a criminal turn in economic regulation, a paradigmatic shift wherein the coercive apparatus of criminal justice intelligence-driven surveillance, associational profiling, punitive restraint, and carceral state power is progressively appropriated while its normative safeguards, the presumption of innocence, actus reus requirements, evidentiary rigor, proportionality review, fair labeling, proportionate punishment, and judicial due process, are systematically circumvented. 3. Strategic competition and the securitization of the global economy. 20. The post-Cold War period was characterized by a hegemonic narrative of economic liberalization and global interdependence. Trade, investment, and transnational supply chains were widely understood, particularly within Western policy and academic circles, as instruments of peace rather than potential vectors of conflict. International institutions such as the World Trade Organization, WTO, and the International Monetary Fund, IMF, embodied a technocratic vision of depoliticized governance, ostensibly insulated, at least rhetorically, from geopolitical contestation. The embedded liberalism of the Bretton Woods era has given way to a more radical market fundamentalism, premised on assumptions about the pacifying effects of commerce. This normative and institutional settlement has demonstrably eroded. The resurgence of strategic competition between major powers, most prominently the United States, the People's Republic of China, and the Russian Federation, has fundamentally repoliticized international economic relations. Economic activity is no longer presumed benign. It is now subject to systematic scrutiny for its potential to enable technological espionage, facilitate political coercion, or generate strategic dependencies that compromise national autonomy. 21. The COVID-19 pandemic exposed critical vulnerabilities in globalized supply chains, while Russia's invasion of Ukraine underscored the weaponization potential of energy markets and financial infrastructure. For the United Kingdom, this geopolitical shift has been explicitly articulated through successive policy documents emphasizing systemic competition and the imperative to protect critical national infrastructure and sensitive emerging technologies. Economic openness, previously treated as an unqualified policy good, is now rendered conditional upon security assessments that increasingly resemble the risk evaluations characteristic of criminal justice decision-making. 22. National security has undergone a conceptual transformation in the early 21st century. Once primarily circumscribed within the domain of territorial defense and conventional military threats, it is now increasingly invoked to justify legal intervention in domains traditionally governed by economic liberalism, such as foreign direct investment, international trade, financial markets, data flows, and technological innovation. This expansion is neither accidental nor ideologically neutral. Rather, it reflects structural transformations in the global political economy driven by renewed great power rivalry, accelerating digitalization, and the perceived inadequacy of existing international economic governance regimes to manage what are now characterized as strategic risks. 23. China's expanding conception of national security is increasingly refracted through regulatory review mechanisms, including competition and related economic governance regimes. This trend suggests a more aggressive securitization of market regulation, as ostensibly technocratic tools such as merger control, antitrust enforcement, and sectoral licensing are deployed to police foreign participation in strategically sensitive sectors and data-rich industries. 24. China's expanding national security scheme has a distinct extraterritorial dimension, particularly in the regulation of data. The Hong Kong National Security Law and the Data Security Law, for example, project Chinese security claims beyond territorial borders, with implications for foreign firms handling important or core data linked to China. This dynamic can be situated within a broader contest over the governance of personal data. As Gao shows, the United States, the European Union, and China advance competing conceptualizations of data that shape transnational data flows, with Chinese legislation asserting far-reaching extraterritorial reach. 24. In the United Kingdom, these shifts have been crystallized through a succession of legislative and regulatory developments, most notably the NSIA, alongside expanded sanctions regimes under the Sanctions and Anti-Money Laundering Act 2018, National Security Act 2023, export controls pursuant to the Export Control Act 2002, and enhanced economic crime enforcement mechanisms. What is striking is not merely the quantitative growth of executive power within these domains, but the increasingly pre-crime logic underpinning them. Risk-based intervention, preventive enforcement, procedural secrecy, and broad executive discretion, institutional hallmarks of contemporary criminal justice, now structure the regulation of economic activity deemed security sensitive. Criminalizing economic advantage. 25. Modern great power competition is no longer shaped chiefly by the threat of armed conflict, but by the exploitation of economic interdependence. States now contest within a global market that functions as an arena for power projection. Trade corridors, supply networks, and digital infrastructures, once praised as emblems of shared prosperity, have turned into tools through which influence is exercised and vulnerabilities are revealed. The unseen hand of the global economy increasingly advances overt geopolitical objectives. Investment and corporate integration today entail dangers reaching well beyond balance sheets. Foreign direct investment can operate as a channel for compelled technology transfer, while cross-border mergers and acquisitions may discreetly open access to sensitive intellectual property, personal data, and vital infrastructure. What once appeared as strictly financial transactions now become potential acts of strategic positioning, granting rivals a foothold inside the neural networks of advanced economies. The line dividing legitimate commerce from covert statecraft has blurred almost beyond recognition. Within this transformed landscape, the once clear boundaries separating civilian and military functions, public and private authority, and lawful enterprise from strategic manipulation have become permeable and unstable. Digital platforms now serve simultaneously as conduits of connection and instruments of influence, rendering information itself a fiercely contested arena of power. The outcome is a more intricate and elusive form of rivalry, waged not only through coercion or deterrence, but through code, capital, and connectivity, where every transaction bears the imprint of strategy. 26. States have increasingly fused national security oversight with the machinery of economic regulation, transforming once neutral investment regimes into instruments of strategic defense. Security review regimes now turn not on proven misconduct, but on the anticipation of prospective harm. A transaction need not evidence wrongdoing. The mere possibility that it might advance hostile purposes, often inferred from classified intelligence or conjectural threat analyses, can justify governmental intervention. This preemptive rationale marks a deep transformation in governance, where suspicion alone suffices to activate coercive power. Such sweeping discretion tests the limits of lawful oversight. When determinations rely on opaque standards and undisclosed evidence, the rule of law risks subordination to security imperatives. The result is a regulatory sphere where precaution drifts into arbitrariness, eroding the distinction between legitimate defense and excess. 27. The post-Cold War consensus that economic interdependence would serve as a pacifying force in international relations has demonstrably collapsed. The liberal internationalist presumption that ever-deeper trade and investment linkages would inevitably foster cooperation, mutual comprehension, and enduring peaceful coexistence now appears, in retrospect, idealistic and theoretically undersubstantiated. Economic interdependence has not abolished strategic rivalry. Rather, it has reconfigured its modalities, generating novel channels through which states can project influence, discipline adversaries, and secure geopolitical advantage through ostensibly commercial means. This transformation is perhaps most vividly exemplified in the evolving Sino-Western relationship. China's incorporation into global markets following its 2001 accession to the World Trade Organization rested on optimistic expectations of gradual normative alignment with liberal capitalism. These assumptions have proven fundamentally erroneous. Instead, China has cultivated what the literature increasingly identifies as a form of state capitalism, a hybrid political economic order that fuses market dynamics with comprehensive state direction, party oversight, and long-term strategic industrial planning. Far from convergence, the result has been structural divergence and intensifying systemic rivalry. 28. The United Kingdom, despite its post-Brexit emphasis on global Britain and ostensible commitment to economic openness, has responded by dramatically expanding national security controls over foreign investment, trade, and technology. The NSIA 2021 constitutes the most far-reaching peacetime constraint on foreign investment in British economic history. Concurrently, China has instituted parallel frameworks, the National Security Law, Counter-Espionage Law, as amended 2023, and Data Security Law, that subject economic engagement to intensive state oversight and potential criminalization through expansive national security doctrines. China's security and counter-espionage architecture rests upon a web of interlocking statutes, with the 2015 National Security Law articulating an overarching notion of comprehensive security and the 2023 Counter-Anti-Espionage Law delineating detailed counterintelligence and status security competencies. China's contemporary security regime, akin to that of the United States and the United Kingdom, is structured around a broad and integrated vision of national security, extending well beyond traditional defense to encompass political, economic, cultural, technological, cyber, and even ideological domains. Divergent paths in economic security governance. 29. Contemporary economic security governance signifies a profound paradigmatic transformation in the intricate relationship between state authority and commercial enterprise. Across diverse jurisdictions, legislators have enacted sweeping statutes that fundamentally reconfigure the traditional presumption of economic openness, substituting anticipatory, preventive security rationales for conventional reactive regulatory paradigms. It is therefore analytically imperative to examine the statutory architectures of China, the United States, and the United Kingdom through a parallel, comparative lens to illuminate the foundational scope of the law. Definitional elasticity, standards of liability, extraterritorial reach, enforcement rigor, and the strategic integration of security imperatives with broader industrial policy objectives. By subjecting each jurisdiction to identical evaluative criteria, we can trace the emergence of convergent legal forms marked by anticipatory coercion, risk-based classification, and the criminalization of commercial conduct, while simultaneously discerning substantive divergences in jurisdictional breadth, enforcement intensity, and the prioritization of national security vis-à-vis economic dynamism. VA China's Law. 30. China's approach to economic security governance operates through an integrated legislative framework that reconceptualizes the relationship between state, economy, and society. The foundational National Security Law of 2015 established an expansive definition of national security encompassing political security, territorial integrity, military security, economic security, cultural security, social security, science and technology security, information security, ecological security, resource security, and nuclear security. This holistic conception, termed comprehensive national security,
总体国家安全观
provides the juridical foundation for regulatory intervention across these domains, treating economic activity not as a distinct sphere requiring protection from state intrusion, but as a source of potential security threats requiring systematic surveillance and control. 31. Article 19 of the 2015 National Security Law explicitly mandates that economic development must safeguard national economic security and establishes state authority to implement necessary controls and restrictions over foreign investment, foreign trade, and economic cooperation when national security requires. This provision structurally reverses the presumption of economic carte blanche, since commercial activity is permissible insofar as it serves, or at minimum does not threaten, national security interests. The juridical logic is preventive rather than remedial. The state asserts a priori authority to restrict transactions based on potential security externalities rather than demonstrated harms. 32. Subsequent legislation has operationalized this schema through specific regulatory mechanisms. The Counter-Espionage Law of the People's Republic of China 2014, substantially amended 2023, criminalizes a broad range of conduct involving foreign entities. The 2023 amendments expanded prohibited activities beyond traditional espionage to encompass any acts that seek, provide, or disclose documents, data, materials, or items related to national security and interests. This formulation employs deliberate indeterminacy, granting security agencies extensive discretion to designate information as security sensitive. Commercial due diligence, market research, supply chain audits, and routine business intelligence activities potentially fall within this expansive prohibition, as the law does not require that the information be classified or that the actor know of its sensitive status. 33. Criminal liability under the Counter-Espionage Law operates through a tiered penalty structure. Article 110, Espionage crime, prescribes fixed-term imprisonment of not less than 10 years or life imprisonment for joining espionage organizations or accepting tasks from them. If circumstances are minor, 3 to 10 years. In especially serious cases involving grave harm, the death penalty applies. Article 111 criminalizes illegally providing state secrets or intelligence to foreign entities, with identical sentencing ranges. The 2023 amendments effectively expand state secrets or intelligence to include any documents, data, or items related to national security interests, creating a broad, strict liability risk for commercial actors handling information later designated as sensitive. VB the United States, extraterritorial security. 34. The United States maintains the world's most expansive export control regime, constructed through a layered statutory scheme that extends domestic law across global supply chains. The foundational authorities include the Export Administration Regulations, 15 CFR Parts 730-774, the International Traffic in Arms Regulations, 22 CFR Parts 120-130, and emergency economic powers authorized under the International Emergency Economic Powers Act, 50 U.S.C. 1701 to 1708, and the Export Control Reform Act of 2018, 50 U.S.C. Section 4801 et sec. 35. Under U.S. law, the definition of an export encompasses not merely physical shipments, but intangible transfers including emails, cloud access, software updates, source code, and oral communication. 15 CFR Section 734. The Deemed Export Rule, 15 CFR Section 734.13, treats the release of controlled technology to foreign nationals inside the United States as an export to that individual's home country, directly regulating universities, laboratories, and private research environments. This definitional expansion subjects routine academic collaboration and corporate training to export control licensing requirements, effectively nationalizing knowledge transfer within domestic borders. 36. The U.S. system is distinctively extraterritorial. Through the Foreign Direct Product Rule, 15 CFR Section 734.9, expanded 2020 to 2022, foreign-made items fall under U.S. jurisdiction solely because they are produced using U.S. origin software, technology, or equipment. This allows U.S. authorities to impose licensing requirements and penalties on non-U.S. companies with no physical U.S. presence, effectively extending U.S. export law across global supply chains. The International Emergency Economic Powers Act authorizes the President to declare unusual and extraordinary threats to national security, foreign policy, or the economy, and to regulate transactions accordingly. A standard of indeterminacy comparable to China's national security interests formulation. VC the United Kingdom's intermediate position. 37. The United Kingdom occupies an intermediate regulatory position, combining territorial controls with limited extraterritorial reach. Under the Export Control Act 2002, C28, and the Export Control Order 2008, SI 2008/3231, As amended, implementing the UK Strategic Export Control Lists, the UK regulates military, dual use, and surveillance technologies, including intangible technology transfers and technical assistance. UK law incorporates extraterritorial elements, particularly Article 4 of the Export Control Order 2008, especially regarding military items and weapons of mass destruction. Individuals, not merely corporate entities, face criminal liability. 38. The NSIA represents the United Kingdom's most significant reconfiguration of investment regulation. Departing from earlier reliance on competition law frameworks prioritizing market efficiency and consumer welfare, the NSIA establishes national security as an independent, paramount regulatory objective. The Act confers extensive powers upon the Secretary of State to review, impose conditions upon, or prohibit acquisitions across 17 designated sensitive sectors, including artificial intelligence, defense, critical infrastructure, data infrastructure, quantum computing, and synthetic biology. 39. The NSIA's statutory trigger for intervention is the mere possibility that a transaction may give rise to a risk to national security. A formulation authorizing coercive intervention absent any demonstration of actual threat, harmful intent, or wrongful conduct. Transactions within designated sectors require mandatory notification and ministerial approval. Completing a transaction without approval renders it void ab initio and attracts both civil penalties up to £10 million, or 5% of worldwide turnover, and criminal sanctions, including imprisonment for up to 5 years. VD indeterminacy and delegated authority. 40. All three jurisdictions employ deliberately vague standards that delegate substantial interpretive authority to security agencies, though the rhetorical framing of such delegations varies. China's 2023 counter-espionage law exemplifies this technique through its expansion of protected categories to include documents, data, materials, or items related to national security and interests. This open texture formulation lacks definitional boundaries, enabling retrospective designation of commercial information as security sensitive. Similarly, the national security law's mandate for necessary controls and restrictions provides no threshold criteria for triggering state intervention. 41. The United States achieves comparable indeterminacy through the International Emergency Economic Powers Act's authorization to address unusual and extraordinary threats, a standard that requires no showing of imminent harm or specific intent. The Foreign Direct Product Rules application to items produced with U.S. origin technology creates line-drawing problems regarding de minimis U.S. content, resolved through administrative discretion rather than legislative criteria. The Entity List, 15 CFR. Part 744, Supplement Number 4, operates through administrative designation without requiring adjudicative findings of wrongdoing. 42. The United Kingdom's NSIA similarly employs the may give rise to a risk standard, coupled with 17 sensitive sectors defined through secondary legislation. The absence of quantitative thresholds for risk or guidance on mitigating factors grants the Secretary of State essentially unreviewable discretion to prohibit transactions based on speculative security concerns, v.e. erosion of justice. 43. A convergent feature across all three regimes is the deployment of strict liability for procedural violations and the attenuation of intent requirements for substantive offences, though the severity of penalties varies. China's counter-espionage law establishes what amounts to strict liability for possession, transmission, or disclosure of broadly defined state secrets and intelligence. Criminal liability is not contingent upon demonstrated intent to harm national security, nor even upon awareness that the information is classified. The law criminalizes failure to report suspected espionage, refusal to cooperate with investigations, or obstruction of security operations, attracting substantial criminal penalties including lengthy incarceration regardless of subjective awareness. 44. The United States enforces export controls through a hybrid liability structure. Civil enforcement under the Export Administration Regulations operates largely on strict liability, meaning violators face substantial fines and administrative sanctions regardless of knowledge or intent. Criminal prosecutions under 50 U.S.C. Section 4819 and the International Emergency Economic Powers Act, 50 U.S.C. Section 1705, generally require proof of knowing or willful violations. though the threshold for knowledge can be satisfied by constructive knowledge of export requirements or deliberate ignorance. Penalties include up to 20 years imprisonment for criminal violations. 45. The United Kingdom's NSIA creates a strict liability offence structure for procedural non-compliance. Penalties apply regardless of subjective intent or awareness of the legal obligation. The offence of completing a notifiable transaction without approval carries a potential 5-year prison sentence, without requiring proof of knowing violation or actual security threat. This represents a fundamental departure from orthodox criminal law principles requiring mens rea for serious offences. While the Supreme Court has emphasised that criminal liability without fault should be exceptional and narrowly construed, the NSIA attaches severe penalties, including lengthy imprisonment, to conduct involving neither subjective fault nor any actualised security harm. VF extraterritorial reach. 46. The jurisdictions diverge significantly regarding territorial scope, though all three assert authority beyond traditional borders. China's technology control framework remains largely territorial and administrative. The Technology Import-Export Regulations, 2019, divide technologies into prohibited, restricted, and permitted categories, with state involvement concentrated at licensing, approval, and contract review stages. The Export Control Law, 2020, extends controls to dual-use items, military products, and technologies related to national security, but its structure resembles conventional trade regulation. Although Article 44 contains general extraterritorial language, enforcement has focused mainly on Chinese exporters and activities occurring within China, rather than systematic regulation of foreign firms abroad. 47. The United States maintains the most expansive extraterritorial regime. The Foreign Direct Product Rule subjects foreign manufactured items to U.S. jurisdiction based solely on the use of U.S. origin software or technology. The entity list and various country-based licensing requirements effectively compel non-U.S. companies to comply with U.S. export controls as a condition of accessing U.S. technology or markets. This extraterritoriality functions as a form of global regulatory export, extending U.S. legal standards to commercial activities with no territorial nexus to the United States. 48. The United Kingdom occupies an intermediate position. Article 4 of the Export Control Order 2008 establishes extraterritorial jurisdiction over UK persons engaging in trafficking or brokering activities abroad, particularly regarding military items and weapons of mass destruction. However, UK extraterritorial reach is narrower than that of the United States, focusing primarily on UK nationals and resident companies, rather than asserting jurisdiction over entirely foreign transactions. Official NSIA annual reports and guidance describe the Secretary of State's assessment process, SS23 NSIA, as involving broad risk evaluation, including entity activities and acquirer characteristics. Affected parties may receive only minimal reasoning for adverse decisions, with detailed justifications withheld on grounds of protecting intelligence sources and methods. 69. While judicial review of ministerial decisions is theoretically available on conventional public law grounds of illegality, irrationality, and procedural impropriety, it is substantially constrained by doctrines of curial deference in national security contexts and by the practical difficulty of challenging decisions when the evidential basis remains classified and inaccessible. 49. This approach closely parallels terrorism-related asset freezing regimes, control orders, and terrorism prevention and investigation measures, TPIMs, as criminal law and constitutional scholars have extensively documented. Such mechanisms risk fundamentally hollowing out procedural justice by transforming fair hearing guarantees into mere formalities, while maintaining surface appearances of legal regularity. This is underwritten by a move towards preventive justice, where states increasingly use criminal law like tools to try to prevent or reduce the risk of anticipated future harm, rather than to punish past wrongdoing. This includes criminalizing and regulating conduct at an early stage to allow authorities to intervene, incapacitating suspected future wrongdoers, and imposing extended measures on past wrongdoers based on their predicted future conduct, all in the name of public protection and national security. 50. The rise of the preventive state captures an intensification of the state's security role as threats to economic security and demands for economic protectionism, increase prompting states to prioritize new practices of preventive criminalization. Policing and punishment that may promise greater security but impose burdensome costs and pose threats to civil liberties. The European Court of Human Rights has consistently held that Article 6 ECHR, guaranteeing fair trial rights, applies to proceedings determining civil rights and obligations, potentially encompassing investment decisions with significant economic consequences. In A v United Kingdom, the court held that use of secret evidence without adequate procedural safeguards violated fundamental fairness principles. Nonetheless, the NSIA regime operates with minimal procedural protections when classified material is relied upon, creating potential convention compatibility concerns that remain judicially untested. 51. The practical consequence is substantial legal uncertainty. Economic actors cannot reliably predict what transactions will attract ministerial intervention, what conditions may be imposed, or what reasoning supports adverse decisions. This unpredictability undermines core rule of law values. Raising conceptions of law's guiding function emphasize predictability, clarity, and accessibility. Fuller's principles of legality similarly require prospective, clear, and consistent rules. When national security serves as an indeterminate trump card, supported by undisclosed evidence, and subject to minimal oversight, law's capacity to guide conduct is fundamentally compromised. VG enforcement intensity and the criminalization of market activity. 52. All three jurisdictions treat economic security violations as serious criminal matters, though enforcement intensity and penalty severity vary. China's enforcement relies primarily on administrative sanctions under Articles 34-39 of the Export Control Law, 2020, including warnings, fines, license suspension, and corrective orders. Criminal liability under the counterespionage law applies more selectively but carries severe sanctions: life imprisonment and, in extreme cases, the death penalty. The enforcement pattern emphasizes administrative compliance for commercial violations while reserving criminal sanctions for cases involving alleged foreign intelligence connections. 53. The United States enforces export controls as a form of national security criminal law. Civil penalties under IEEPA can reach millions of dollars per violation. Criminal prosecution under 50 U.S.C. Section 4819 carries penalties of up to 20 years imprisonment. The enforcement regime is both expansive and severe, with the Bureau of Industry and Security and the Department of Justice treating export control violations as priority national security matters. The result is a regulatory environment where even inadvertent violations trigger severe civil penalties, while prosecutors retain discretion to pursue criminal charges in cases involving geopolitical sensitivity. 54. The decision in Learning Resources, Incorporated v. Trump, squarely addresses the limits of using national security and emergency statutes to justify tariffs. The court held that the IEEPA does not clearly delegate to the president the power to impose import tariffs, emphasizing that tariffs are a form of taxation constitutionally reserved to Congress, and invoking the Major Questions Doctrine to require explicit congressional authorization before the executive may adopt such measures under the guise of emergency economic powers. 55. The United Kingdom similarly treats export control violations as serious criminal offences found in secondary legislation, such as the Export Control Order 2008, SI 2008/3231. Though penalties are typically less severe than those in the United States, the NSIA introduces imprisonment for procedural violations, creating a 5-year maximum sentence for notification failures regardless of security harm. This criminalization of procedural noncompliance represents a significant expansion of the carceral dimension of economic regulation. VH Strategic Industrial Policy Integration. 56. Each jurisdiction integrates security regulation with strategic industrial objectives, though the explicitness of this integration varies. China's technology governance framework explicitly prioritizes technological self-sufficiency and strategic advantage. The Made in China 2025 industrial policy and the dual circulation strategy articulate objectives of achieving dominance in strategic technologies, while reducing dependency on foreign suppliers. These are implemented through legally binding directives protecting technology transfers, licensing, and joint ventures. The Export Control Law and technology import-export regulations function explicitly as instruments of industrial policy, restricting outbound technology transfers to preserve domestic competitive advantage. 57. The United States similarly deploys export controls as instruments of industrial policy and geopolitical competition, though often framed in defensive terms. The CHIPS Act and various semiconductor export controls aim to maintain U.S. technological leadership by restricting China's access to advanced computing capabilities. The Foreign Direct Product Rule and Entity List designations function as industrial policy tools, reshaping global supply chains to disadvantage targeted entities. I.e., EPA authorities are explicitly deployed to pressure allies, restructure supply chains, and enforce strategic alignment, effectively conscripting private firms worldwide as enforcers of U.S. foreign policy. 58. The United Kingdom's NSIA similarly facilitates strategic industrial policy, though with less explicit articulation. The 17 designated sectors align with UK industrial strategy priorities, allowing the state to restrict foreign acquisition of capabilities deemed critical to future economic competitiveness. The Act enables industrial planning through the mechanism of security review, though without the explicit self-sufficiency rhetoric characterizing Chinese or US industrial policy. The comparative analysis reveals convergent legal forms across China, the United States, and the United Kingdom. All three employ expansive definitional standards that delegate authority to security professionals. All three attenuate mens rea requirements for economic security violations. All three criminalize procedural non-compliance. And all three integrate security regulation with strategic industrial objectives. The primary divergences lie in jurisdictional scope, where the United States asserts unprecedented extraterritorial reach, while China remains largely territorial, and in enforcement severity. Where the United States combines massive civil penalties with lengthy criminal sentences, China reserves extreme sanctions for politically sensitive cases. And the United Kingdom occupies an intermediate position with significant but less draconian penalties. 59. None of these regimes maintains the procedural safeguards associated with traditional criminal law or administrative due process. All operate through preventive logic that treats risk as equivalent to harm, and all prioritize security imperatives over economic openness. The emergence of these parallel regimes suggests a global transformation in the legal architecture of economic governance, characterized by the securitization of commercial activity and the normalization of exceptional regulatory powers within ostensibly peacetime legal orders, chilling incentives and market-based enforcement. 60. The procedural complexity, interpretive uncertainty, and severity of potential penalties systematically encourage overcompliance by risk-averse commercial entities. This phenomenon, extensively documented in counter-terrorism financing and anti-money laundering contexts, manifests as widespread de-risking. Financial institutions, technology companies, and trading firms proactively disengage from lawful but politically sensitive markets, transactions, or client relationships presenting elevated perceived regulatory risk. Economic actors thereby effectively function as de facto security agents, internalizing and operationalizing state security priorities through private decision-making processes lacking democratic accountability or transparency. Decisions profoundly affecting international trade patterns, investment flows, and market access are made within private corporate compliance departments, subject to confidentiality and lacking procedural safeguards, rather than through accountable public institutions subject to judicial oversight and parliamentary scrutiny. 61. While such privatized enforcement mechanisms may strengthen certain security objectives through pervasive and comprehensive market surveillance, they simultaneously erode core principles of transparency, legal accountability, and democratic governance. This institutionalized approach systematically obscures the distributional consequences, unintended externalities, and potential discriminatory effects arising from the implementation of security policies. The Financial Action Task Force has observed that excessive de-risking can severely undermine financial inclusion and legitimate commercial activity, but existing regulatory frameworks offer minimal guidance regarding proportionate, context, sensitive risk assessment, and mitigation. 62. From the perspective of criminal law theory, this constitutes a clear case of overcriminalization, representing the deployment of coercive state power well beyond morally legitimate boundaries. When otherwise well-intentioned economic actors are effectively prohibited from engaging in lawful activity by the credible threat of severe sanctions for unforeseeable or ambiguously defined violations. The conceptual distinction between criminal law and administrative regulation becomes increasingly blurred. This pervasive chilling effect extends the reach of state coercion far beyond formal legal limits, constraining economic liberty without explicit statutory authorization and simultaneously undermining the legitimacy of law as a principled, fair, and predictably enforceable constraint on human behavior, reordering the norms of global economic intent. 63. This engenders a chilling effect extending sovereign coercive power beyond traditional juridical limits, necessitating de-risking maneuvers where corporations preemptively desert integral markets, technologies, and logistics networks to bypass regulatory ambiguity. Paradoxically, these protocols fail to bolster Western strategic posture within Sino-economic rivalry. Rather, they auto-cannibalize expansion. By instrumentalizing volatility, the US and UK transmute their legal architectures from innovation enablers into levies on transactional trust, reallocating capital from generative investment toward compliance superfluity and opportunity. Cost inertia. The consequence isn't fortified security, but eroded GDP. As AI infrastructure expenditure, the primary catalyst of American growth, retracts into a restricted defensive orientation, and as international capital migrates toward jurisdictions providing stable regulatory frameworks. This preventive shift catalyzes the exact economic atrophy it intends to forestall, making the economic conflict insurmountable by structurally destabilizing the industrial foundation upon which geopolitical hegemony depends. The systematic expansion of unilateral national security claims by both China and the United Kingdom, alongside similar developments in the United States, the European Union, and other major economies, places acute strain upon the World Trade Organization's multilateral trading system. Article 21 of the General Agreement on Tariffs and Trade, GATT, the national security exception, was historically treated as a narrow, self-judging safeguard invoked only in genuine emergencies. During the post-war liberal order, states exercised considerable restraint in invoking Article 21, recognizing that its abuse could undermine predictability essential to international economic law. 64. This normative consensus has effectively disintegrated. Article 21 is now regularly employed to legitimize trade-restrictive actions, tariffs, quotas, technology transfer controls, and investment bans, advancing primarily economic or industrial policy aims rather than responding to bona fide security threats. China invokes national security to rationalize diverse trade limitations. The United Kingdom cites security justifications for investment screening and export regulations that extend across wide sectors of economic life. The United States has relied on Article 21 to levy steel and aluminum tariffs and to curtail technology exports directed toward China. 65. The WTO dispute in Russia, measures concerning traffic in transit, marked the first substantive panel examination of Article 21's scope. The panel adopted an interpretation granting states considerable discretion while maintaining minimal objective review. States possess substantial autonomy to define their essential security interests, but claims must relate to one of Article 21's enumerated categories: fissionable materials, arms traffic, or actions during war or international emergency. Subsequent disputes have further tested these boundaries without establishing clear limiting principles. 66. The systemic risk posed is the progressive fragmentation of international economic law itself. If national security exceptions are interpreted expansively, applied unilaterally, and enforced without meaningful international oversight or substantive normative constraints, the core predictability, coherence, and legal stability that international economic law affords to market actors are gradually and cumulatively undermined. From the perspective of criminal law theory, this dynamic closely parallels the perils associated with the normalization of emergency powers, where measures initially justified as temporary responses to genuine crises increasingly become routine instruments of governance, effectively transforming legal exceptions into operational norms. In this context, Agamben's concept of the permanent state of exception becomes analytically salient, illustrating how exceptional powers once normalized risk displacing the rule itself and eroding the structural integrity of both domestic and international legal regimes. 67. Criminalizing economic conduct intensifies these difficulties. When governments reinforce national security trade limitations with criminal sanction, as both China and the United Kingdom, do they dramatically elevate non-compliance costs. This diminishes room for negotiated resolutions and renders violations politically unacceptable. Criminal enforcement additionally obstructs WTO dispute settlement because defendant states contend that altering criminal legislation following adverse WTO decisions would compromise sovereignty and domestic legal integrity. The convergence of criminal law with international economic law generates especially stubborn conflicts. 68. Bilateral investment treaties and free trade agreements containing investment chapters have historically provided foreign investors with substantive protections and access to investor-state dispute settlement (ISDS). These protections include fair and equitable treatment, full protection and security, prohibition on uncompensated expropriation, and free transfer of capital. Such provisions were designed to depoliticize investment protection, providing neutral adjudication of investor claims rather than requiring diplomatic intervention by home states. Nevertheless, investment treaties generally include national security exceptions, frequently patterned on GATT Article 21, allowing states to adopt measures they consider necessary for safeguarding essential security interests. As governments increasingly invoke security rationales to defend investment restrictions, these exceptions are undergoing intensified legal and political scrutiny. China has relied on such clauses within its treaty network to justify an array of regulatory constraints. The United Kingdom's NSI likewise unsettles traditional principles of investment protection. Its mandatory notification regime, potential transaction prohibitions, and criminal sanctions for non-compliance constitute marked departures from the liberal investment framework that such treaties were originally crafted to uphold. 69. Investment tribunals confront challenging questions. To what extent should security exceptions be interpreted? Are states' security determinations genuinely subject to review or effectively self-judging? What standard of evidence must states produce to substantiate security-based restrictions? Can criminal sanctions for treaty breaches meaningfully deter investor claims? These questions carry significant implications for the future trajectory of investment law. If security exceptions are interpreted expansively with minimal review, investment treaties risk becoming largely hortatory. Conversely, if construed narrowly with rigorous review, tribunals may be compelled to make security determinations that exceed their institutional competence. The invocation of national security exceptions in economic governance implicates the customary international law defense of necessity, codified in Article 25 of the International Law Commission's Articles on the Responsibility of States for Internationally Wrongful Acts, ASIWA, which permit states to preclude wrongfulness only where the impugned conduct constitutes the only way to safeguard an essential interest against a grave and imminent peril. However, emerging technologies complicate this strict scheme since remote kill switches in electric vehicles, embedded malware in critical infrastructure, or quantum decryption capabilities create latent vulnerabilities where the imminence of peril is inherently ambiguous. Threats may remain dormant for years before activation, rendering traditional temporal assessments of necessity problematic. 70. Recent investment arbitration jurisprudence has arguably softened these rigorous requirements. In Sempra Energy International v. Argentina award, the ICSID tribunal merged treaty-based non-precluded measures clauses with the customary necessity defense, importing Article 25's stringent only way and non-contribution conditions into contractual security exceptions. But the CMS Annulment Committee subsequently clarified that these defenses operate distinctly since treaty exemptions function as threshold requirements precluding breach entirely, whereas necessity excuses otherwise wrongful conduct. This doctrinal confusion, coupled with the expansion of essential interest beyond state survival to encompass economic stability, suggests an evolutionary softening of necessity's strict limits, potentially enabling more expansive preventive security measures than classical international law contemplated. 71. The criminalization of investment activity introduces an additional layer of complexity to the framework of investment protection. Traditional investment law presupposed that investor-state disputes arose primarily from civil or administrative matters, including regulatory takings, discriminatory taxation, breaches of contract, or other non-criminal forms of state interference. The initiation of criminal prosecution against investors or their personnel, however, constitutes a fundamentally distinct category of state action, with qualitatively different legal and political implications. Investment tribunals are institutionally and doctrinally ill-equipped to assess the legitimacy of criminal proceedings, the proportionality or appropriateness of criminal penalties, or the underlying motives driving prosecutorial discretion. Nonetheless, if states can invoke criminal prosecution as a shield against scrutiny under investment treaties, they acquire a potent and potentially coercive instrument to circumvent international obligations, effectively insulating contested actions from adjudication and weakening the enforceability of treaty-based investor protections. 7. A fragmented law and the rise of competitive governance. 72. The parallel development of expansive national security frameworks by multiple major powers creates what international legal scholars characterize as legal fragmentation, overlapping, potentially conflicting national regulatory requirements displacing uniform multilateral rules. This fragmentation substantially increases transaction costs, generates legal uncertainty, and intensifies geopolitical friction between competing regulatory spheres. The United Kingdom's post-Brexit approach vividly illustrates this tension since it is rhetorically committed to the rules-based international order while simultaneously relying upon increasingly expansive unilateral security assessments, substantially insulated from international legal oversight. 73. This transformation reflects a broader movement from multilateral cooperation toward competitive governance. States now increasingly perceive international economic regulation as a domain for projecting power rather than exercising mutual restraint. Braithwaite's concept of regulatory capitalism posits that leading powers will ever more frequently deploy domestic regulatory instruments to extend influence and structure global markets, producing a fragmented order of rival regulatory empires in place of unified multilateral norms. China explicitly pursues technological sovereignty and strategic autonomy through national security laws. The United Kingdom, the European Union, and the United States similarly pursue economic security through unilateral regulation designed to reduce strategic dependencies. 74. The consequence is an accelerating balkanization of the global economy into rival spheres of influence. A Chinese sphere organized around status security imperatives and Western sphere, structured by hybrid logics of liberal norms and strategic competition. Economic participants confront untenable choices over which domain to prioritize. Technology supply chains must now be duplicated rather than integrated. Data requires localization rather than unrestricted circulation. Innovation becomes constrained by security imperatives instead of market incentives. These trends markedly diminish global efficiency and welfare while intensifying geopolitical frictions. When one major power broadens its national security controls, others react with comparable or stronger measures to avoid asymmetric exposure. The outcome is a ratchet dynamic in which security restrictions steadily intensify across leading economies, while countervailing forces for openness or liberalization remain weak. Criminal law theory cautions explicitly against this dynamic. Powers originally conceived as exceptional emergency measures often expand incrementally and solidify inter-enduring elements of the legal order. 7. B. Reconfiguring international cooperation. 75. Bridging the gap between state-centric capitalism, exemplified by China, and market-driven Western models remains a profound challenge. For China, the role of the state and SOEs as instruments of policy is a red line, while Western democracies operate under market principles emphasizing competition. Full systemic convergence is therefore unrealistic. Cooperation is more likely to succeed through targeted, pragmatic engagement in areas of mutual interest, such as climate policy, financial stability, or public health, where both state-owned and private actors can participate without requiring ideological alignment. Establishing trust-building mechanisms, including shared standards, transparency measures, and third-party verification, can facilitate collaboration even amid structural differences. Over the long term, incremental agreements and institutional layering can create interoperable frameworks that allow coordination without forcing either system to abandon its core principles. In this sense, the goal is not to harmonize systems entirely, but to manage differences and enable functional cooperation where necessary. 76. At the international level, a renewed and robust commitment to multilateral governance frameworks and shared legal standards is both necessary and urgent. In the absence of common procedural and substantive principles constraining unilateral assertions of national security, the concept risks degenerating into little more than a rhetorical trump card, rather than a legally disciplined doctrine subject to meaningful review and constraint. Several avenues of reform therefore merit serious and systematic consideration. 77. Firstly, states should negotiate plurilateral agreements that establish harmonized standards for investment screening, export controls, and the implementation of sanctions. It is worth noting that the extraterritorial expansion of national security sanctions raises acute international legal concerns regarding jurisdictional overreach and the erosion of multilateral governance frameworks. As he demonstrates, unilateral sanctions regimes increasingly blur the distinction between kind and degree of coercion, while deploying strong-arm rather than legitimate long-arm jurisdiction, asserting prescriptive authority so extreme that it exceeds lawful bounds. The primary-secondary sanctions dichotomy compounds these violations. Primary sanctions regulate domestic actors within prescriptive jurisdiction, whereas secondary sanctions penalize foreign entities for transactions entirely outside the sanctioning state's territory, effectively coercing third states to comply with unilateral foreign policy objectives. This could be intent standard, punishing conduct based on hypothetical future risk rather than demonstrated wrongful purpose, mirrors the preventive justice logic pervading investment screening regimes. Substituting conjectural threat assessment for established international legal constraints on sovereign coercion. The OECD's ongoing work on investment security frameworks provides a potentially valuable foundation for such convergence. These agreements could codify common definitions of security-sensitive sectors, articulate uniform procedural requirements for security reviews, and create mechanisms for coordination to prevent regulatory arbitrage, overlapping jurisdiction, and conflicts of legal authority. While achieving a comprehensive global accord, including participation by China, may be unrealistic in the near term, coalitions of like-minded democracies could establish shared frameworks that meaningfully reduce legal fragmentation and enhance predictability, accountability, and coherence within the democratic sphere of international economic governance. 78. Secondly, WTO members should actively pursue negotiations to clarify Article 21 and related national security exceptions, establishing more rigorous procedural and evidentiary requirements for the invocation of security justifications. Such reforms could encompass mandatory notification obligations, detailed articulation of specific security concerns, clearly defined temporal limits on security measures, and meaningful, enforceable dispute settlement review. While states may resist any perceived limitation on their discretion, the institutional interest in preserving the integrity, predictability, and stability of the multilateral trading system could provide a compelling incentive for compromise. The alternative, progressive legal fragmentation and the potential erosion or collapse of the WTO framework, ultimately serves no state's long-term economic or strategic interests. 79. Thirdly, ongoing investment treaty negotiations should seek to develop more sophisticated and carefully calibrated security exceptions that balance the legitimate regulatory autonomy of states with robust investor protections. Such frameworks could incorporate burden-shifting mechanisms, where security invocations trigger heightened procedural obligations, independent expert review, and mandatory compensation obligations whenever security measures materially impair established investments. These approaches acknowledge genuine security imperatives while simultaneously constraining their potential use as pretextual tools for economic protectionism, discriminatory interference, or de facto expropriation of private capital. 80. Finally, states should develop robust mechanisms for jurisdictional coordination to address extraterritorial conflicts arising from overlapping or competing assertions of regulatory authority. Such mechanisms could take the form of bilateral or plurilateral agreements that establish clear hierarchy rules whenever multiple states claim jurisdiction over the same transaction or actor, articulate standardized procedural requirements that must be satisfied prior to extraterritorial enforcement, and create formalized dispute resolution processes to adjudicate jurisdictional conflicts in a predictable and legally coherent manner. The International Law Commission's extensive work on extraterritorial jurisdiction provides a valuable normative and scholarly foundation for these initiatives, offering both doctrinal guidance and practical principles to structure coordination efforts in ways that reduce uncertainty, prevent regulatory arbitrage, and reinforce the legitimacy and stability of cross-border legal regimes. 8. Conclusion. 81. This essay has contended that contemporary economic security governance embodies a profound criminal turn, whereby preventive logics from pre-crime jurisprudence have migrated into the realms of commerce, trade, and investment. Examined through the concept of preventive justice and securitization theory, this transformation functions not simply as regulatory expansion, but as a juridical inversion of the norm of punishing completed wrongs. These regimes now employ anticipatory coercion, substituting categorical risk assessments for individualized culpability and conjectural harm for demonstrable threat. The securitization of economic life, executed through performative declarations framing commercial or technological behavior as existential dangers, legitimizes the suspension of orthodox safeguards, normalizing strict liability penalties, procedural opacity, and broad executive discretion as core instruments of economic governance. 82. The comparative analysis demonstrates a pronounced structural convergence across otherwise divergent constitutional systems. Across China's comprehensive national security framework, the United States' extraterritorial export control regime, and the United Kingdom's NSIA 2021, shared features prevail, including expansive definitional ambiguity, thereby empowering security technocrats. This has led to an erosion of mens rea in favor of strict or no-strict liability and the criminalization of procedural omissions. Nonetheless, meaningful distinctions persist since the United States asserts extraordinary extraterritorial scope through the Foreign Direct Product Rule and entity listings, effectively globalizing its security priorities. China's architecture, though all-encompassing, operates primarily territorially and bureaucratically, reserving acute criminal sanctions for exceptional cases. The United Kingdom occupies an uneasy middle ground, rhetorically committed to the rule of law, but deploying exceptional penalties, such as 5-year imprisonment for non-notification, that stretch those commitments to their outer limits. 83. These trajectories carry significant implications for the international legal order. The routinization of GATT Article 21 invocations and the expansive reading of national surety exceptions in bilateral investment treaties illustrate a growing fragmentation of multilateral economic regulation. As major powers escalate reciprocal preventive controls to offset perceived vulnerabilities, the global economy drifts toward balkanization into rival spheres defined by nationalism rather than stable, ruler-based norms. The ensuing chilling effects and privatized enforcement mechanisms, whereby market actors, fearing punitive unpredictability, disengage preemptively from sensitive sectors, extend state coercion beyond formal law, undermining economic efficiency and eroding democratic accountability. 84. Addressing these challenges requires a constrained consequentialist framework that reconciles legitimate security imperatives with non-derogable procedural foundations. Unchecked consequentialism threatens to validate any measure promising speculative utility. Rigid deontology, by contrast, risks disabling effective protection. Normatively, procedural guarantees, notice, reasoning, and impartial review must operate not merely as abstract rights, but as epistemic tools improving decision quality and constraining arbitrariness. Evidentiary thresholds should scale with coercive intensity, demanding reasonable suspicion for prohibitions and mens rea for criminal sanctions. Procedural opacity must yield to mechanisms such as special advocates, security-cleared judicial oversight, and periodic declassification. Likewise, sunset clauses and empirical accountability devices are vital to forestall the entrenchment of temporary emergency powers as permanent governance norms. 85. Without deliberate restraint, the protective reflex toward domestic industries will cement chilling effects across international markets. Once governments prioritize safeguarding national producers through tariffs, quotas, or subsidies, global commerce contracts transforming arenas of shared growth into fragmented, inward-looking systems inimical to innovation and efficiency. Shielding domestic sectors from competition diminishes incentives for productivity, inflates consumer and business costs, provokes retaliatory measures, and suppresses trade volumes, ultimately impairing global prosperity and collective welfare. Upholding the rule of law amid systemic rivalry, therefore demands that security remain subordinate to legal discipline, not as rhetorical validation, but as a narrowly circumscribed exception to the presumptions of openness, proportionality, and procedural integrity.